So this is in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 23-21324FH. I have Salvatore Malaro appearing on behalf of the defendant, and I have Dave McCready appearing on behalf of the prosecutor's office. This is the date and time. I just have the probation. No, this makes sense. Why is this just a violation of probation today?
Yeah, Judge, I just noticed that myself. We had a prelim back in April that got bound upstairs. The transcript's probably due next week, I think, like middle of July, at which point we would be looking at motions to file.
So why don't we move this over to the September 4 date? Because that, if you get transcripts mid-July, that gives you 6 weeks to do your motions.
Well, I think Mr. McKenzie wants things to move a little faster. Is that correct?
Yeah, very.
Well, it takes
trial in 180 days. I didn't have a prelim for 90 some days. I'm trying to argue that.
So you're waiting on your transcripts, correct?
Yeah.
So they come when they come. They have a time period that they're allowed to get those done by, and they're not going to be done till July. And so you really, your attorneys probably advised you that you don't want to proceed to get those transcripts.
So in order to file a motion for my prelim being pushed back 3 separate times due to the prosecutor filing bad writs or however, I just would.
Well, I can't argue the merits of that today because I got to wait for motions, and your attorney will file the motions.
So that means I can't have a trial in 80 days. That's correct.
Do you want me to set you for trial now?
Yes.
Your Honor.
Yes, Ms. Teskey.
This is a whole separate probation violation from his new crimes. Like, this is a probation violation for him being terminated from treatment. It has nothing to do with his new crimes.
Before we even get into the courtroom chaos, let's set the stage. Because today's video is basically a highlight reel of what happens when confidence, misinformation, and courtroom reality collide. We're looking at multiple hearings, multiple judges, and multiple defendants who seem absolutely convinced that rules either don't apply to them, or could be debated away with attitude, bad logic, and yes, even AI chatbots. This is the kind of content viewers have been begging for. Firm judges, zero patience, and defendants learning in real time that court is not a comment section.
You today, Mr. McKenzie, because we're only here on the violation of probation. Your violation of probation has nothing to do with your new charges. So if you want to plead to your violation of probation from being terminated for getting into a dispute with another inmate in the program, I'd be more than happy to take your plea, but understand you're automatically have to go to prison on this.
Judge, when I spoke to Mr. McKenzie about that, he indicated he wanted to separate here.
All right, I can set you a trial on this.
Yeah. So
Ms. Teskey, how long do you need for a trial to get your witnesses from Eaton County on this?
Your Honor, I would say 2 weeks.
2 weeks? All right, Miss Adams, I need probably an hour for a violation of probation trial.
And Your Honor, for the record, I'm sure Mr. McKenzie would oppose any testimony by Zoom.
Oh.
Is that correct, Mr. McKenzie?
yes.
Okay.
Can he do that, Your Honor?
Yep. So, yeah, it's just someone that works there. That's all you need is someone that works there, right? So, all right. So, Ms. Adams, I'm looking for about an hour.
Yeah.
Who are you going to call as?
I'll bring the book in, Judge. I'm not finding an hour.
Okay. And Mr. Malaro, your client would testify potentially. And then who else will you be calling as a witness?
And discuss that with him. Do you have some witnesses?
Yeah, and it's Tamia Dillard.
She runs the program.
Tamia?
Yeah.
Tamia Dillard, was he there?
No, she's a lady that runs it. They never took a statement or nothing from me.
Well, they don't have to. They don't have to.
Well, Judge, I've spoken to her in the past. I think she runs the program.
All right.
She does, and she was who I would be calling for a witness as well.
Okay. Okay. So.
Are you definitely going to call her, Ms. Teskey?
Yes.
So I would not have to subpoena her then?
No.
All right. You okay with that?
Yeah.
All right.
Ms. Antoine, could I speak for a second?
Nope, I'm looking for a date, so you gotta wait a minute.
This is the moment where things quietly but decisively go off the rails for the defendant. What he doesn't seem to grasp, and what the judge is laying out very clearly, is that probation violations exist in their own legal universe. New charges don't magically pause them, delay them, or give the defendant leverage. The RAP program he was in is literally designed as an alternative to prison, meaning it's already a second chance stacked on top of a second chance. Getting terminated from that program isn't a technicality. It's the fast lane to incarceration.
Yes,
Those sunglasses, or are they prescription?
prescription.
Do you see the plea questionnaire waiver of rights form I have in front of me?
I see them, yes.
Did your attorney go over this document with you?
Very briefly.
Well, maybe if you weren't 18 minutes late, you could add more time with your attorney, right?
I forgot my money. I had to turn around.
Maybe you should have been here maybe 20 minutes prior to your hearing to go over this with your attorney, correct?
Correct.
And Your Honor, I do have a copy of it in front of them as well.
Thank you. And the fact that you forgot the money, is it the court's problem?
A little bit. I mean, but
Oh, I forgot it for you?
No, it's my problem, but it made it your problem.
It did make it
By
my problem. It made
postponing-
it the district attorney's problem. It made it Mr.
postponing-
Keene's problem.
I apologize.
You are putting my calendar behind right away in the morning.
That's what I have to do stuff, and I have a copy.
Yeah, yep. So he's went over multiple times. You've had Mr. Keene for some time on this case, correct?
Mhm.
Yes?
Yes,
And you've had him for this time when you've been trying to complete the IDIP, correct?
and I have.
Okay, and so Mr. Keene, this isn't the first time he's talked to you about what it means to plead guilty to an OWI third, correct?
Correct.
And he's went over with you what the state would have to prove, correct?
Yeah.
Correct?
Correct.
And he's went over the maximum penalties and the minimum penalties you could face. Is that correct?
Yeah,
And he's went over the offer with you that has been presented by Mr. Renicky to to recommend to the court IDIP guidelines, correct?
This is one of those deceptively dangerous courtroom moments. On the surface, it sounds empowering. I'll set it for trial. But anyone who understands probation violations knows that trial here isn't a reset. It's a gamble with terrible odds. The prosecution doesn't need to prove guilt beyond a reasonable doubt, like in a criminal trial. The standard is lower, the evidence is cleaner, and the witnesses are program administrators with documentation. When the judge explains that prison time is automatic upon termination, she's not threatening, she's warning. This is also where you can feel the patience thinning.
Okay, so it sounds like he did go over all of the information on this plea questionnaire. Is that your signature on the second page?
yes,
So you are 44 years old. You can read, write, you understand the English language. You have not had any drugs, alcohol, or other medications, and you have not been deemed mentally incompetent, correct?
correct.
So do you understand all of those constitutional rights on that document that's sitting there right in front of you?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that by pleading guilty, you're waiving and giving up those rights? You won't be able to have those rights again. You can't plead guilty and say, you know what, Judge, I changed my mind. I want a jury trial. You know, do you understand that?
Yes,
And so by pleading guilty, those rights are going away. You understand that?
yes,
Okay. Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation? I don't allow coffee in here.
I'm sorry.
I only allow water.
Apologize.
Okay. So do you understand that by pleading guilty, you could be deported if you're not a citizen? I have to ask that
Yes,
to everybody. Okay. And do you understand that, again, here, the state would have to prove certain things that on or around May 28th, 2023, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. And this would be a third offense. Do you understand what the state would have to prove?
What would they have to prove?
You operated a motor vehicle,
Okay,
you
yeah, yeah,
drove, you operated, you
Yeah.
turned a key, you had the keys
Okay.
in the ignition, you did something to operate the motor vehicle.
Okay,
and that you were under the influence of an intoxicant. You understand that?
Okay.
Okay. Do you understand they would have to prove that?
Mhm.
Okay. And this is your third offense, third conviction? Right? Is that a yes?
Yes,
Okay. And do you understand that upon conviction, you face a fine of not more than $2,000, that excludes court costs and fees, and imprisonment of not less than 45 days, but no more than 1 year in the county jail? Do you understand that?
yes,
Plus that the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an AODA, OWI assessment and driver safety plan and follow through. You understand that? Yes?
yes.
And you should have done that with the IDIP program, so that should be
It's
covered.
taken care of.
Yes. All right. Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes,
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
yes.
Do you have any questions for your attorney or the court before we proceed?
All right.
And that's all kinds of fun today.
Here's where frustration finally boils over and the mask slips. The defendant openly rejects his court-appointed attorney. Not because of incompetence, but because reality isn't bending his way. Judges see this all the time. Defendants who want representation only if that lawyer promises miracles. But the court doesn't operate on vibes or wishful thinking. When the judge explains that requesting an appointed attorney means accepting one, she's drawing a hard boundary. And once contempt enters the conversation, the tone changes permanently. At this point, the judge isn't reacting emotionally. She's restoring order.
A math question. I just want to know if it's fictional or fact.
Math is usually not fiction. Why,
Yeah.
it's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
Want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not, because quite honestly, we go to law school, so we don't have to do math, but we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
I think it's great. The issue, and it's been up, I'm with, Ms. Anderson, is you had a question about the, grams per 100 milliliters.
Dude,
And
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above the limit.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
Yeah,
maybe it's wrong. I don't know.
yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
it's just that I was measured in thousands, and the law goes by hundreds.
Right out of the gate, this defendant manages to put himself on the court's bad side, and it's entirely avoidable. Being late, unprepared, and casually shifting blame onto the court is the opposite of how you walk into a plea hearing. Judges run tight calendars, and when someone strolls in behind schedule, it signals disrespect whether intended or not. The judge's responses here are sharp, but fair. She's correcting the narrative in real time. Forgetting money didn't become the court's problem. It was made the court's problem. And first impressions matter.
I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce
And yet you blew a .221 allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late.
I
Okay.
apologize.
You're not supposed to be late to court. Okay. You're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance. And now you're here debating.
No, I'm just saying,
Science.
anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a 10th, 2 numerals behind the decimal is 100th.
Yep.
3 numerals behind the decimal is 1,000th.
Well, cut off the 1 because that's what math does. You get to cut off certain things. So you were .22. We'll give you the benefit of the doubt. No more with that 1, that 1,000th gone. So you blew a .22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. It's .08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000 is 100.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's .22. It's .22.
But no, if there's 3 numerals, because if it was point.
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next.
This portion of the hearing is textbook judicial procedure, and it's done deliberately. The judge is building a record that shows the plea is knowing, voluntary, and intelligent. Every question serves a purpose. Age, language comprehension, sobriety, mental competence. These aren't formalities, they're safeguards. And notice how patient the judge remains, even as the defendant gives clipped or distracted answers. She repeatedly emphasizes that once a guilty plea is entered, there is no rewind button, no jury trial, no do-over. This is a court making sure that when accountability lands, it lands cleanly.
Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to
hours.
piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and giving extensions. You're fair. And I'm here. And I'll go to jail, get out. I got a job. And
all right. So are you admitting that you at least blew over a .08 or at least .08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a .221 and I agree that my blood alcohol was at .190.
Okay. All right.
I agree with those.
And so, and do you agree that you operated or drove a motor vehicle while in that state?
I agree to that, yes.
All right, Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty, or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm gonna beat you up. I'm gonna take a gun. I'm gonna take a knife.
None of those.
Anybody threaten to hurt you or anything?
None of those.
Okay. Are you pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a .221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily.
Yes.
Does anyone or are you satisfied with your attorney's services?
This is the moment where confidence crosses into absurdity. The defendant openly admits he relied on an AI chatbot to analyze blood alcohol calculations and seems genuinely surprised that the court doesn't accept chatbot logic over statutory law and lab analysis. The judge's response is brilliant because it's restrained. She doesn't mock him. She redirects him back to reality. Courts don't debate scientific thresholds during plea hearings, and judges don't rewrite legislation on the fly. When she offers a trial and explains exactly what that would unleash, expert testimony, lab analysts' maximum penalties, it's a final off-ramp. And when the defendant chooses jail instead, that's not surrender.
I don't know any.
Mr. Keene, you said that's not a defense, correct?
Yeah, and yes, and we have discussed that in basic math and other things along with it extensively.
All right. Okay. You have any? No. All right. So based on this, the OWI third, count 1. How do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed with count 1. A judgment of conviction will be entered today. Mr. Lamprecht, anything you want to add or say to the court?
Nothing that I haven't already.
Well, I mean, what are you doing employment-wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he
Yeah.
is there waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years, the lab analysts, they learn science and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law. I ensure that that the community is protected in certain ways. OWI is again serious. You're putting yourself at risk. You're putting others at risk. The fact that you blew a .221 had blood alcohol content from blood at 0.19 is serious. Ensure that you have more jail time than what's being sentenced here today. All right.
I like you and you're a fair judge. I'm not trying to piss you
Then
off at all.
stop talking.
Okay.
I need to ensure that the public is going to be protected. And that means to ensure that you've learned a lesson, you're rehabilitating, you've done the IDIP program. That's a positive program. It's taking you more than most to do that program, but you've at least completed the program, which is positive. You're going to have the ability to get your license back or get an occupational prior to the end of your revocation. Your attorney is very correct. The next OWI will be a felony. The one after that is mandatory minimum prison sentences. So it's very important that you figured it out now and that you're not going to engage in this type of behavior before or again. What I will do is I will follow the IDIP guidelines. Despite all of the issues in this case, I'm going to follow the IDIP guidelines. I'm going to assess $1,911 in fines and fees with an additional $10 blood draw fee, 45 days in jail, 24 months of ignition interlock device to be placed on any vehicle you drive. Doesn't mean you need to own that vehicle. If you're going to borrow your mother's vehicle to go down the street to the gas station, it must have the IDIP in it or the interlock in it, or you may not drive the vehicle. 24 months of revocation of driver's license, OWI assessment and driver safety plan, 75 hours of community service. You must report immediately report to jail. And that means that you will have to go sit 48 consecutive hours before you are eligible to be released on monitor. I'm going to tell you, this is where I'm going to be very clear with you, Mr. Lamprecht. I take no excuse. If you are going to be released on monitor, you must prepay at least 30 days in advance. If you are even 1 day late on payment for a 30-day advance, you must sit in jail. You will be immediately terminated off of the monitor. You will immediately report to jail, and you will sit the whole sentence. No good time, no Huber. I was near rubbing alcohol. I ate bang bang shrimp. I do not take that I ate tiramisu and it was made with real alcohol. Okay, I take no excuse. It is an immediate report, no good time, no Huber. Report to jail immediately. Your DNA is ordered.
These hearings are perfect examples of how courtroom confidence without legal understanding almost always backfires. In the first case, a probation violation sealed a prison sentence long before insults were thrown. In the second, a guilty plea nearly derailed itself through lateness, deflection, and misplaced trust in AI over actual law. What stands out most is the judges. Firm, patient, and unwavering in enforcing boundaries. No theatrics. No leniency for nonsense. Just clear consequences tied directly to choices. If you found these cases as shocking or as satisfying as we did, hit that like button, drop your thoughts in the comments, and subscribe for more no-nonsense courtroom breakdowns where reality always wins.